if I can just ask everybody to make sure you're muted through the presentation. There will be an opportunity for you all to ask questions, and if you do want to ask a question, please do use the chat box, which is somewhere up there. And we will look at the questions towards the end. We are allowing an opportunity for questions a little bit later on. So just to introduce myself and my colleague Samantha. So my name is Julie Temple. I hope, well, I think many of you will know who I am. I am co-chair of the Essex and Ipswich branch, and I am also the head of the employment and BLHR team at Birkett Long. And I am joined today by Samantha Randall, who is an associate within the employment and BLHR team. She joined us in August of last year, and I've managed to rope her into joining me as we whistle through a roundup of the employment law changes which have come in and are coming in. As I mentioned, got to remember to push that on, and will be an opportunity to ask questions. Please use the chat box up above, and we will circle back to do those a little bit towards the end of today. So I'm going to pass over to Sam, and Sam is going to get proceedings started.
Thank you, Julie. So firstly, well, we're going to start with a bit of retrospect going backwards to the beginning of the year. And in January of this year, we're now living in post-Brexit times finally. So from the 1st of January, obviously we no longer have supremacy of EU law following Brexit, which potentially might create a couple of uncertainties going forward, because obviously the courts no longer need to follow EU, well-established EU principles. So we might end up seeing the re-litigation of different EU principles, but it might take a while for those to trickle through to down the tribunals before we see any real sort of departure from that. But the current position is that most of the EU law is going to be kind of enshrined into UK law at a more domestic level. However, it does mean that there are some changes. So we've got the treatment of after the protected period because of pregnancy, and in terms of discrimination as well, we have some changes there in terms of the individual doesn't need to have a protected characteristic under the indirect legislation for discrimination. So we also have changes in terms of the direct discrimination outside of recruitment. So if you have an employer that's put a statement out to say that they won't employ someone with a particular characteristic, where they're, even where they haven't had an active part in the recruitment process, that person no longer needs to be a person claiming to have been affected, just by the fact that they've made that statement. So we've got a couple of changes there, but as I said, it'll take a while before that trickles down to before we see that at any real sort of tribunal level. And then coming on to working time. So we've got the introduction of the Employment Rights and Regulations 2023 that has come into force as well from January. And this brought about quite a few different changes in the employment law spectrum. So it makes changes to holidays that we'll see shortly, the consultation process in regards to TUPE, but also in terms of working time as well. So the aim of the regulations really is to try to simplify and make things a bit easier, particularly in terms of reporting and record keeping, and just to try and cut down on that administration burden. So it's been adapted to say that you only need to have adequate record keeping. In terms of the carryover of holidays, so that again, it's the EU principles enshrined into UK law here, so no real changes in that respect, but so the carryover of holiday due to sickness or family leave, that will still apply. So it's been interpreted at a domestic level now. And it also makes a bit more clarity in terms of holiday pay remuneration, so being the normal pay, which could include commission, regular overtime payments, and also for professional and personal status. So that's kind of brings us up to speed to where we are now. And so looking forward to next month, it's going to be quite a busy month for employment law, as it always is. And going back to the working time, so as I said, the employment rights regulations have brought about a number of changes, the main one being to holiday pay. Now, this is only going to affect those who are irregular hours workers or part-year workers. So irregular workers means that the number of paid hours that they work in each pay period during that term of their contract in that year is either wholly or mostly variable, so that's completely sort of unpredictable. Whereas a part-year worker is only, as it says on the tin, required to work part of the year, and that their year and their periods within that year are at least of a week in which they're not required to work, for which they're not paid. So those are the definitions that have been established for those two types of workers. Now, these changes to holiday pay are only for those with holiday years that are on or after the 1st of April. So if your holiday year started in January of this year, these rules won't apply this year, and they won't come into force until your new holiday year starts the following year. So in terms of what has actually changed for irregular and part-year workers, there is the reintroduction, really, of a rolled up holiday pay, so to speak. So the regulations are essentially designed to try and simplify annual leave and holiday pay calculations. So we're going back to a situation of being able to calculate those workers' holiday on the basis of 12.07% of their hours worked. Now, that can be paid either as they accrue it, or it can be paid as a top-up pay to their wages. But it's also just making sure that if you are going down that route, it's making sure that those employees know that when they do take holiday, then they're not going to be paid at that point, because they would have already received that as part of their pay. So in relation to what you need to do if you do have any of these workers, then it would be a case of conducting an analysis of the workforce to see if any of the employees come under this category of workers, and taking advice, obviously, if you're uncertain, and holding consultations with those affected employees about the changes to how their holiday pay is going to be calculated going forward, and also ensuring that your policies and payroll systems are updated to reflect the change as well. So going forward to the usual changes that we see every April, we've got obviously the national minimum wage increases. So for those, there's been a slight change in that we no longer have a minimum wage for those aged between 21 and 22. That's been scrapped, and it now will go from 21 and over. And we can see that that has increased up to £11.44 per hour going forward. And likewise, we've got the various rates there for 18 to 20, 16 to 17, apprentice and accommodation rates. So it's just making sure that obviously from the 1st of April, those are implemented. Now, just to make things confusing, from the 7th of April is when the family pay rates change. So as you'll see on screen, for all of the family pay rates, they're all at the same rate. There is an increase, obviously, from £172.48 up to £184.03, or 90% of that employee's average weekly earnings if lower than that. And then sick pay rates, again, just throwing another curveball in with the 6th of April, we have an increase to £116.75 per week sick pay. We also have increases in the Employment Tribunal compensation awards. So we've got the normal unfair dismissal compensation award is increasing up to £115,115, or 52 weeks pay, whatever is the lower of the two. A week's pay for the purposes of calculating redundancy pay is increasing up to £700, and the daily guaranteed payment for layoffs is increasing to £38. So as Julie mentioned, we're part of Birkett Long. We have quite a big employment team. Part of the reason we've put a slide in terms of training is that obviously there are so many updates this year, and it's going to be quite key that you ensure that your staff are trained and know how to manage these particular changes in the law going forward. So a couple of areas that we can provide training on include obviously equality and diversity, menopause in the workplace, but also bullying and harassment. That one's going to be quite key, particularly from a sexual harassment perspective, and you'll hear more about that from Julie in terms of the update coming up later on this year. And in terms of, again, services we can offer to employers, we do have pretty much a one-stop shop, like a retainer package for any of your HR and employment needs, whether it be you need new policies or contracts updated, or you just want someone to be able to pick up the phone or email with all of these updates that are coming along, that it's easy to feel quite overwhelmed with those and know how to handle and what to do. So we're here to help you navigate through that. So, and now we come on to a brand new type of leave. So this will be coming in April as well. We have carers leave. So this is going to be a day one right, and it entitles that employee to 1 week's leave in any 12-month period. It can be taken in full days or half days, and it will be unpaid. And the purpose of this leave is to provide or arrange long-term care. So what they mean by care is essentially if there is an illness or injury that requires or is likely to require care for more than 3 months, that is considered a disability under the Equality Act, and it also could include issues that relate to old age as well. So this leave is essentially to care for dependents, and a dependent is classed as a spouse, civil partner, child, parent, or a person who lives in the same household as the employee, or a person who reasonably relies on that employee for care. So thinking along the lines of potentially elderly parents that need that care. In terms of the notice that the employee will need to provide, the notice needs to be twice as long as the period that they're needing, plus 1 day. So there'll be a minimum of 3 days notice essentially. And an employer can postpone that leave if the business, if it is likely to cause serious disruption to the business, but they must allow that leave to be taken within 1 month of that postponement. And they need to confirm that in writing within 7 days before that leave is due to start. So with the introduction of this type of leave, it is designed to obviously protect those against treatment for taking that leave, because it will become a statutory right. So there will be a protection from them being subject to detriment or dismissal as a result of that. And that leave for 1 week is regardless of the number of people that they provide care to. It is just a blanket 1 week, no matter if they needed care for 2 children or more. There is no evidence that's needed to request that leave, and it doesn't need to be in writing either. And then coming on to, again, on the lines of family-friendly rights, we have changes to flexible working, which I'm sure a lot of you are going to be aware of, have been quite reported over the last year or so. So this is becoming a day one right. So no longer does an employee need to work for at least 26 weeks before they can request flexible working. So you could find yourself easily in a position where you have an employee that's just started, you've only just negotiated their hours of work, and day one they could put this request in. So it's important to be aware of that. The number of requests is also increasing, up to 2 requests in any 12-month period. Previously it was just 1. And it basically is removing the obligation for an employee to explain or consider the impacts on an employer and how, you know, that they could get around and accommodate their request. It's no longer the employee's duty to do that. And in terms of responding to that flexible working request application, there was a previous period of 3 months that's now been reduced to 2 months to actually deal with the flexible working request and any appeal during that period as well. And in terms of everything else, though, the same 8 reasons to refuse are still there. They remain unchanged. And there is a CAS guidance that's been published in terms of the changes. But otherwise, broadly speaking, requests must be agreed unless they're going to be refused for one of those 8 reasons, and that there is an obligation on the employer to consult and agree that, and unless they agreed to that request, either in person or in writing or telephone, that they must at least consult with that employee regarding their request. So we've then just got the 8 reasons for refusal, and as I said, they remain unchanged. So as long as you can justify one of those reasons, then flexible working applications can reasonably be rejected, provided that you've shown consideration. But generally speaking, the position with the tribunals, as we've seen in recent case law, is coming to an application with a view of how can it be accommodated, rather than the opposite and a more negative view of just refusing it. It's looking at what can an employee do to accommodate that request. We also have changes to paternity leave. So the main change being that previously it had to be taken in a consecutive block of 1 or 2 weeks. Now they don't have to be consecutive. So if an employee decides, they could take 1 week at one time and another week at another time. And this leave must be taken in the first 52 weeks, which is again an increase up from 8 weeks, which is obviously quite considerable. An employee needs to give 28 days notice of this. 7 days notice with adoption, because obviously sometimes the notification is quite quick, that it might not be possible to give such notice. And if there was to be any variation, there would need to be 28 days notice. And this applies to leave where the expected week of childbirth is on or after the 6th of April. We also have changes to redundancy protection. So again, on the lines of family-friendly rights, this is going to be increasing the protection for those on maternity or pregnancy, extending that period of protection until after they've actually returned to work for a period of 6 months. So this is in relation to an offer of suitable alternative employment, in that they would take preference in relation to all others. And as I said, that is being extended. So again, this applies to where there's been a notification of pregnancy on or after the 6th of April this year, and the maternity period ending on or after the 6th of April this year. It doesn't apply to paternity leave, obviously that's under separate regulations. But broadly speaking, it does provide protection for 18 months. So from the date of birth or adoption, up until 6 months after they return. So that protected period is being extended. In cases of miscarriage, if the miscarriage is before 24 weeks, then it would be extended to 2 weeks after the end of that pregnancy that protected period is for. So in terms of what you as employers need to be thinking about, given all of the changes coming forward. So the first thing really is going to be making sure that you review and update any contractual terms. And this also applies to policies as well. So we've got various changes to different policies that are going to be affected. So firstly, in terms of pay notification regarding holiday, flexible workings, obviously that the policy and procedure is going to be changing in terms of the number of requests and how quickly they are dealt with. Paternity leave, obviously we have the changes to the amount of blocks that they can take, and in terms of time off for dependents also. I also mentioned obviously briefly earlier in terms of harassment, dignity at work, equal opportunities, and we'll be hearing more about the reason why that you might want to review those policies shortly when I hand over to Julie. And lastly, obviously, we have got some new types of leave coming in force in terms of carers leave and neonatal leave. So with those, there will be brand new policies that you'll need to ensure are updated and included in your handbooks. And also it's making sure with all of these changes that there is the awareness and training for staff and managers about how to handle any new requests under these new legislative changes. So I'm now going to be handing back over to Julie, who's then going to kind of give you a bit of a foresight into the future going forward. Oh, Julie, I think you're muted.
You're mute.
Blast botheration. I was paying attention, apart from the fact that I was muted. Okay, so I'm going to have a look at what is coming in terms of what we know, and also perhaps just look at what other things might be coming in that have been mentioned, because of course it is an election year, so no doubt there will be lots of posturing between now and the election date from when that is set. But let's move on before I find myself in trouble. So in terms of TUPE, transfer of undertakings, bracket protection of employment, close bracket regulations, I hope that many of you don't need to worry about this, but I do know that a number of you on this do get involved. So under TUPE, which is a transfer of employment from one employer to another, if there is a purchase of assets or purchase of a part of a business, there is an obligation on both the outgoing and incoming employer to inform and in some circumstances consult with elected representatives or representatives within their organisation that are already in situ for this purpose. From the 1st of July, there is going to be a lowering of the ceiling in terms of when there is a requirement to elect representatives if there are none in place. Now, those reps can be elected employee reps, or it can be an existing recognised trade union representative who is already in place. Currently, there is an exemption for 10 for businesses with 10 employees. That is going up to 50. So if you are part of an organisation that is involved in a TUPE transfer with less than 50 employees, you can inform and consult if needed directly. There is also a second exclusion, which is where the transfer itself involves less than 10 employees. So if you are in an upcoming situation where there is a transfer on or after the 1st of July, then you might be in a situation where you don't need to worry about engaging in electing of representatives if you are in those two circumstances. And as I say, that only applies if there are no existing representatives in place that are there for the purposes of informing and consulting in relation to TUPE transfers. So that's that one. The next one is in relation to tips. So this applies within the hospitality sector, and there is going to be a requirement for all tips which are earned during shifts to be passed on to the employees rather than in some circumstances retained by the employer. Those tips are going to have to be fairly allocated, and there will be a requirement for them to be paid no later than the month after they are earned. So, for example, I'm working in a hotel today. I earn tips today. I get paid monthly, but I would need to be paid those tips by way of a fair allocation, no later, assuming I'm paid monthly towards the end of the month, no later than April. Good question, Sue. I will check that point in relation to other sectors where there are tips payable, for example, in the beauty sector. And maybe Sam, if you wouldn't mind just doing some quick research on that for me, I would be grateful. Also, where tips are earned, there needs to be a written policy that applies. So if you are in that sector, and we'll clarify that point that Sue has just raised, then we will there's a little bit of work for you to do, both in terms of determining what is a fair allocation and also making sure that you have a written policy in place. So next up, we're expecting by September of this year the predictable terms and conditions provisions to come in. So these apply to individuals who work patterns that are less than certain, both in terms of hours and times of work, and also individuals who have fixed term contracts of 12 months or less. Now, if an individual in either of those circumstances, and this does include agency workers as well, has 26 weeks service, which does not have to be continuous, they will have a right, we expect from September onwards, to be able to make a request for a more predictable working pattern in terms of their work with the organisation that they are engaged with. And there are, as you might expect, going to be grounds on which the business can refuse that request. And some of these, I am sure, will look quite familiar to you. And I've realised something's gone a little bit wrong with the slides, because one of the points is just down in the in the footer there. But the first one is in terms of cost. It's not cost effective to meet the request. The request would have a negative effect on ability to meet customer demand. There is an inability to recruit to accommodate the request. It will have a negative impact on other aspects of the business. There isn't enough work to do in relation to the times of the request. And what you can't read down at the bottom, and we'll correct these before we send the slides out, is there are planned changes within the business that means that the request can't be accommodated. Now, as I say, I expect that for many of you, some of those will be familiar because they do mirror to a degree the grounds on which flexible working requests can be refused. So also, if you are in a situation where you think you might have requests for more predictable working patterns within some parts of your workforce, I would strongly recommend that you obtain in advance the ACAS Code of Practice, which is currently in draft at the moment, but is highly unlikely to change to any significant degree before it is implemented to cover the legislation, which, as I say, we're expecting to come in September. So please do start to think about that, and not necessarily start to talk with individuals where you think those applications may be made, but do start to think about what sort of approach you might take in relation to those requests. Now, Sam has mentioned that there is going to be a need for you to be looking at your equal opportunities and harassment policies. That is in anticipation of legislation that we are expecting to come in again in October of this year. Now, just to put this into context, within the disability discrimination under the Equality Act, employers, in order to avoid liability for the actions of their employees, the discriminatory actions of employees within their business, have to evidence that they have taken all reasonable steps in relation to preventing individuals from acting in a discriminatory manner. Under this change that, as I say, we're expecting to come in October of this year, that is being watered down slightly in relation to the prevention of sexual harassment. At least it's being watered down slightly in my view, in the sense that the test is going to be, have reasonable steps being taken to prevent sexual harassment. But the sting in the tail, so to speak, is going to be that where a business has not taken reasonable steps to prevent sexual harassment taking place within the workplace, and there is a finding that there has been sexual harassment, the individual's compensation can be increased by up to 25%. So currently we have an all reasonable steps test, but with no option to increase compensation. In relation to sexual harassment only, we're going to move to a reasonable step. Have you taken reasonable steps to prevent it? But with the option for employment tribunals, in effect, to impose a penalty on businesses and increase compensation by up to 25%. Now, I know through my advising innumerable commercial clients over the years, that certainly some of those clients might be taking a little bit more note in terms of allegations that are being made within certain teams or certain departments or certain locations, and perhaps being less willing to pass those circumstances off as, in inverted commas, banter or something similar, where there is a risk of compensation of up to 25% being imposed. And as Sam has said, a critical part of being able to evidence that reasonable steps have been taken is, one, looking at policies and procedures in terms of reviewing them, refreshing them, making sure that staff are aware of them, but also making sure that managers are trained, individuals are trained in terms of what is and what is not acceptable in terms of behaviour, specifically in relation to sexual harassment. But quite frankly, why wouldn't you use the opportunity to refresh training and knowledge in any event on a much wider discriminatory basis? And also, it's all very well having the best policies and procedures and people being aware and indeed being trained, but if those policies are not being followed through, if they are not being enforced, then you are in a position of potentially being shown to not having taken reasonable steps to prevent sexual harassment in the workplace. So we've got a little bit of time in terms of preparing for that. So, please do think about the steps that you have taken in the past, but also the steps that you can be taking between now and October in terms of that process. And there is a case that I've spoken about in one of these updates in the past, where training was actually put in place, but then within a matter of weeks, an individual was acting in a manner that was contrary to that training. So you do also need to think about the effectiveness of the training and monitoring and ensuring that it is refreshed as you kind of move away from a position where you are kind of doing a good blast, so to speak, to make raise an awareness. So the next thing that we are expecting to come in April of next year is a right to neonatal leave. And again, some of you who will remember my triplets being born, who incidentally are now 11, may be aware that my triplet spent 6 weeks in the neonatal ward at Ipswich Hospital. So this is something that is quite close to my heart, and I'm very pleased to see is going to be introduced. So what do we mean by it? So what it is it is a day one right. So individuals who join your organisation will have the right to this leave from day one. And there is a distinction between the right to take the leave and the right to be paid for the leave. The right to be paid is if an individual has been employed for 26 weeks or more and meets the lower earnings limit, which is the LEL that you can see on that slide there. The right is to take 1 to 12 weeks leave, and it relates to babies who are born and enter into neonatal care of up to at least 7 days rather, before they reach 28 days of age. And the right is to take leave within a period of 68 weeks of birth. As I say, there's a distinction between the right to be able to take the leave, which is a day one right, and then the right to be able to be paid. We're expecting the paid leave to be at the same rate as other family friendly leave, if I put it like that. And also what will then happen, what we're anticipating will happen, is the neonatal leave will apply at the start of absence, and then the maternity leave rights will kick in addition. So as I say, I'm pleased to see that development coming in. In terms of other things, as I mentioned earlier, an election year. The first one isn't, I don't think, connected with any party posturing in relation to the forthcoming election, but it is in relation to fees for employment tribunal cases. Many of you will remember we had a situation where there was a fee structure in relation to individuals having to pay a fee to be able to bring a claim, and then various other fees I can't even remember what they were now, in terms of the various stages of a case progressing through to hearing and indeed beyond. The proposal currently, if memory is serving me correctly, is that there's going to be a flat fee of £35 per claim, and that can be a claim which involves multiple claimants. And there is also going to be a second fee in relation to an appeal to the Employment Appeal Tribunal, and again that's going to be a flat fee of £35. Now, whether this will be introduced remains to be seen. Whether it will have, if introduced, the impact that we hope as practitioners it might, particularly in circumstances where within our team certainly we are starting to see the trend again of employment tribunals cancelling hearings at the last minute because they do not have judicial resources in order to deal with the claims, which is in turn pushing things back and causing undue delay in circumstances where actually it's taking quite a long time for hearings to be listed anyway. So that's the context in which the fees situation is being considered. If you are interested, please do get involved. The consultation is open, I believe, until the end of March. If you just Google Employment Tribunal fees consultation, it will take you to the consultation page. You can read that document in a little bit more detail and get involved. So, general election, Labour have announced an intention for equal pay to be introduced connected with disability as a protected characteristic, and also ethnic minority as protected characteristics in the context of equal pay. And as you will know, currently equal pay just extends currently in relation to pay comparisons for male compared to female. So I do personally, and the views are all my own. I personally think that would be a very good step in the right direction, and shore up and consolidate the steps that we are taking in relation to protections in relation to discrimination. So that's kind of where we are, and we are very much ahead of time in terms of timing. So before we just go into questions, I just wanted to raise a couple of cases that have come out relatively recently and we haven't yet had a chance to do articles on these. So if you do subscribe to our newsletters or check the Birkett Long website, you'll see these coming up over the next week or so. So the first case, and I became aware of this earlier this week, just relates to when protection for against dismissal or detriment might apply if an individual is making or has intimated that they wish to make a request for example, paternity leave, or for example, flexible working. And the particular case, I'm just going to make sure that I am not transposing things in my head. So the particular case related to an indication that an individual was going to take parental leave. They say there was no formal application, but they'd obviously been a little bit of a discussion and an intimation that the individual wanted to take parental leave. There was then a question as to whether or not the individual, who was then subsequently made redundant, could bring a claim that they were automatically unfairly dismissed because they had intimated they wanted to take parental leave. And the Employment Tribunal has held that in order for protection to apply, there does not need to have been a formal request, i.e. a request made in writing or in compliance with the relevant statutory right that an individual might want to take. Now, I haven't had a chance to look at the specific statutory wording in relation to this, but I must admit, when I read this, I was slightly surprised that the individual had sort of pursued this up to the Employment Appeal Tribunal level, because to my mind, if an individual is intimating that they wish to take a particular or exercise a particular right, in my view, that means that the protections should kick in or start, that the potential protections rather should start to kick in from that point. So please do bear that in mind if you do take a strict approach in relation to when individuals may or may not be protected in such circumstances, and take a view that a formal application would need to have been taken, then you might need to adjust your position in relation to that. The second case is in relation to a dismissal where an individual had posted a racist joke on the employer's intranet. In those circumstances, the employer had taken into account various mitigation factors, but taken a decision to dismiss the individual for what they considered to be gross misconduct. The individual lodged an Employment Tribunal claim, and the Employment Tribunal didn't agree that a dismissal was in the reasonable range of responses in those circumstances. And in terms of the test, in order for a dismissal to be deemed fair in the context of an unfair dismissal, the decision to dismiss must be within the range of reasonable responses. And as I say, the Employment Tribunal in this case decided that it was outside of the reasonable range of responses to dismiss the individual in these circumstances. The employer appealed, and the Employment Appeal Tribunal sided with the employer and said, in effect, despite the mitigating circumstances that the individual had put forward in terms of showing remorse, that they were willing to undergo diversity training, which may well have mitigated what could have been a dismissal down to a final written warning or indeed less, the Employment Appeal Tribunal concluded that a dismissal was within the range of reasonable responses. So whilst an employment tribunal might take a different view, and indeed other employers might take a different view, it was still one of the potentially reasonable consequences of the findings in relation to the employee's actions. So they were just two of the cases that I've seen recently that have come to my attention that I want to just bring to your attention in the sense, because I think they have some sensible practical consequences for you, and might just adjust your thinking in terms of day-to-day business, so to speak. So if we come on to questions, I can see, Sam, you've been just dealing with a couple of things as they've come up. So do you want to pop yourself off mute, and then we can have a look at those questions if there's any outstanding. And if any of you do have any questions that you've been holding back, whether it's on anything that we've spoken about today, and I'm happy to open it up to more, then please do drop them into the chat. Have we got any questions, Sam, that we need to answer, or have you managed to?
I think I dealt with them, but I mean, we can have a chat about them.
Okay. So, well, I know. Sorry, go on.
So we had Sue that was asking about the tips. So currently, because obviously things are still a bit uncertain with that act coming in, we only have a draft statutory code of practice at the moment. I had a quick flick through that, but it just refers to hospitality and other tipping sectors. So it does leave it a bit wide open, really, as to what other tipping sectors there are. But I presume it just means where tips are commonplace in those kind of areas. So, you know, if you get tips quite commonly, you're probably better off having a policy on it just in case.
Yeah, and I would say, I'm going to put my head in the block and say that the beauty industry will be one such sector, and I, you know, whether that's nails, whether that's I'm out of my depth on
I'd say
this
sort
one.
of hairdressing as well. I think it's
absolutely.
quite common that you tip your hairdresser. So those types of things. So obviously predominantly it was drafted for hospitality, but you know, it does encroach other areas as well where tips are quite commonplace. Yeah,
absolutely. And yes, so I think and well, I would imagine, again, I'll put my head in the block here and say that what is a tipping sector might well be the subject of litigation in the future, but
I mean, it's still a draft code of practice at the moment, so that might change and it might evolve as, you know, once that comes into place, and like I said, as things be litigated, and it might change. We might get some clarity, but I wouldn't hold your breath.
Absolutely. All right. Well, I know Steve asked a question just early on in terms of if his organisation already provides for paid leave of 2 weeks for carers, and how to deal with that. And actually, this will be the same for any slight variation in rights, or indeed the neonatal rights that are coming in. If you already have policies in place, one, you'll need to check to make sure that you're providing for the minimum that the statutory provisions provide for. And if you're providing for more, you know, you're going further than the statutory provisions provide, then just kind of look at the wording and then potentially sort of say words to the effect of, you know, look, this is over and above the statutory position, and therefore your statutory rights are taken care of. It's a similar situation really to if you pay occupational sick pay, company sick pay over and above statutory. So it's just to say, in effect, your statutory rights are included within our enhanced rights, and making sure that the minimums are taken care of. So that was just one question whilst you were speaking, and just for the benefit of others who may not have been following the chat.
We did have another question from Laura in terms of time off for dependents, and especially in light of the carers leave, and it's just making it clear that they are two separate types of leave.
Yeah,
they
absolutely.
will run concurrently with each other.
Yeah, so just to pick up on that, the time off for dependents is, the way that I see it, is it's more of a right to deal with an emergency, and the carers leave is more of a right to deal with circumstances that can be planned, for want of a better expression. So, you know, for example, last week my dad was due to go into hospital. I could have applied to take time off in relation to that under the carers leave, whereas it wouldn't have I wouldn't have been covered under the time off for dependents as we know that now, because the time is to deal with an immediate emergency rather than a sort of planned situation. So absolutely right, Sam, they're two separate rights. You're going to have potentially a situation where individuals could be taking time off for dependents as we know it now, with very short notice or no notice, and then either relatively shortly after that or in the future wanting to take carers leave for what follows on from that circumstance. All right.
I think that was it in terms of questions, and unless anyone wants to fire away one quickly before we end the webinar.
Okay. Well, hopefully, Rebecca, you managed to get sound, but we are recording the event today. So if any of you have been sidetracked or not been able to hear clearly, then it is being recorded. It will be posted onto our YouTube channel. And again, if you just Google the Essex and Ipswich YouTube CIPD branch YouTube, you'll get access to the recording from there in a short period of time. Hopefully that will be up in the next week or so. So please do have a look there, and there's a whole host of other recordings from previous events where we've been given agreement to record the event by the individual presenting. So what I'll do is I'll just pop Sam and my contact details up there. I did pop them in the chat earlier as well. So if any of you do have any questions that you want to ask us that you'd prefer not to do in this public forum, then please do. If any of you would like to talk to us about how we might support you, both in terms of what we've spoken about today, but also what's coming in, preparation of policies, assistance with that, then please do get in touch. Let's just quickly see.
I think we had another question or two.
Yeah, so
we had Jamie that asked, where an employee has regular hours contract and undertakes bank and variable hours work, does this fall in the definition of irregular?
Right, where are we? What time was that?
4:54.
4:50. Oh, gone the wrong way. Has regular hours contract and undertake. So are they two separate contracts?
Sounds like it, potentially with the same employer though. So
yeah, I think the regular hours contract, in my view, would not be irregular for almost obvious reasons. The bank variable potentially would be, and in effect, I guess you're going to have potentially two separate. I'm thinking this is to do with calculation of holiday.
Yeah.
You've kind of got your regular holiday entitlement and then your irregular holiday entitlement, and certainly as a general rule of thumb, anyone where you've got irregular hours, it is going to be far better to take the approach of the percentage accrual and payment than faffing about, frankly, that's a technical term, with anything else. And as I say, that's a very general rule of thumb. And I am very much looking forward to a day when I don't have to talk about holiday pay and holiday at these events, but whether that day will come, I'm not sure.
We had a question from Sue.
Yeah.
What are your views on employees refusing to return to the office? I think we could be here all day with that one.
we could be here all day with that. And on that topic, I was at the branch committee meeting on Monday evening, and we will be launching a hot topic online session in relation to sort of flexible working from home and all of that sort of thing. But in terms of, and I'm going to use an expression that I use quite a lot and I don't like using, but it's going to depend on both the employees' reasons for wanting to refuse to return to the office, the employer's reasons for wanting the employee to return to the office, and everything in between. I mean, I think the world of work has quite clearly changed beyond all recognition, hasn't it? Since March 2020, frankly, and businesses and individuals are still unpicking how that fits in with their own organisation, how they want to work, their family situation, and so on and so forth. So I think that's probably the best that I can give in terms of a view on that. I don't know whether you've got anything else to add to that, Sam.
I mean, I think this is going to tie in really with flexible working as well. We're probably going to see an influx in flexible working requests, especially with the changes coming up. So there was a recent case in the tribunal on flexible working where we had an employee that had worked from home during the whole period of COVID and ever since. And they requested to work from home and carry on doing so. And the tribunal really sort of commented that really employers should be looking at how that request can be accommodated and, approaching it in a bit more of a positive light rather than, just wanting to get people back in the office for the sake of it. It's really going to be looking at what that employee does and, what was the need for them to be in the office in terms of their duties and role. So, it's going to be one of those case by case basis ones that you have to consider.
Yeah, I mean, I think, collaboration, talking is always going to be a sensible approach. And I mean, I'm slightly disappointed that the changes to flexible working is removing the obligation on an employee to consider and outline what they consider the potential implications of their application could be for the organisation, because it means that I'm not saying in all cases, but it certainly removes the position whereby they're forced to think about it. And it potentially means an employer's got a bit more of an uphill struggle if there are, and I use this term loosely, but legitimate reasons for refusing a flexible working request. And we have the 8 reasons, but you do also have to think about the risk of discrimination claims on the grounds of sex or on the grounds of disability, in a whole host of different circumstances, and indeed other circumstances if applications are made for other reasons. But I think if both parties are entering the conversation with an open mind and thinking about what the business needs, I would hope that there should be some ability to meet somewhere in the middle. But it is, I am afraid, going to depend on the organisation, on the individual, what their role is, what realistically can be done from home, what realistically needs to be done in the workplace. And thinking about the reasons, and maybe thinking about whether training's needed for managers to be able to manage individuals where they're not right in front of them, because it's a different situation, isn't it? You're less able to see what people are doing, and potentially moving towards a position of trust rather than expecting individuals to be at their desk 9 to 5, so to speak, wherever that desk might be, or if might not be a desk, in fact. All right, so so Andrew has just asked the claimant and respondent details, so I've got them open. So the racist joke one was Voltex UK Limited and Biolas, which I hope I've pronounced correctly, and the unfair dismissal parental leave intimation to take, was Wright v Hilton Food Solutions. So they're the two cases that we mentioned earlier. All right, so we finished a little bit quicker than we were anticipating. Hopefully that does mean that we've answered everyone's questions as we've gone through. So I'd just like to thank everybody for your time today. It's been great to see so many of you this afternoon, and thank you for all of your lovely comments in the chat, those of you who have said thank you, etc. If you do want to stay in touch with Birkett Long, then please do scan that QR code. You'll be able to fill in a form and get on our newsletters, or do get in touch with either Sam or myself, or indeed any member of the team. We'll be very happy to talk to you, make sure you're on the mailing list, and also discuss anything that we might be able to support you with. So thank you very much. Do look out for that hot topic session on flexible working and so forth. We'll get that up as soon as we can, and have a lovely rest of the evening.